Corrupticate State Attorney Brian, whoops, Freudian slip there. I meant John Fahey, the prosecutor in the COP-TUAH case, managed to straddle the line between defending and prosecuting the former state police sergeant so insultingly that I decided to make an entire video just to expose how much of an unethical clown he actually is. Let's talk about it. What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer. Admittedly, when I first heard that Sergeant Brian Fahey had been charged criminally, my initial reaction was pure glee. And then I saw what the charges actually were, and while I was disappointed, the optimist in me insisted that we try to give the benefit of the doubt. I thought, well, maybe they're going light on him on the state side because the feds are about to step in. Maybe there's a DOJ investigation a brewing. But then I remembered that this was probably not the DOJ that would be willing to charge a cop where no one died and the color of law part was at least arguable in both directions because he was off duty and was at his home. But when I got a text from Sean Paul the other day asking me for my thoughts on this hearing and I hadn't seen it, my initial impression was that it was obvious BS, but I also said in the video that I did on the rebuttal that all I saw was finger painting and bullshit and minimal skill in the art of persuasion. And I have to admit, I was wrong about the latter. As I stepped back to look at the entirety of what we saw in that hearing, I realized that John Fahey is not a minimalist. He is a master manipulator. And he played the people of Connecticut, and in some ways, even Sean Paul, like they were his own personal violin. For now, let me show you the relevant portions of the video for context, and then we'll pick back up on the other side and talk about my thoughts on this case.
Thank you, Your Honor. This is down for an AR application by Mr. Fahey. I suspect the best way to proceed about this is to allow Attorney Ment to address the court first. And then allow Mr. Reyes, the victim in this matter, to address the court. And then I do have a few comments about the charges, since there's been much talk and many emails to me about the charges before Your Honor rules on that.
Good morning, Your Honor. The court does have our application for AR in front of it. The statute was created exactly for situations like this. The statute, I believe, has been in place for more than 60 years. And it is in place in cases where there has been a first-time offense by someone who the court can find is not likely to reoffend in the future. And that's exactly what you have today. You have a disorderly conduct charge, a C misdemeanor by someone who has not offended in the past and clearly has no reason to reoffend in the future. And I believe that this diversionary program, this pre-trial application for accelerated rehabilitation, is quite appropriate in these circumstances. I understand there will be an objection, and perhaps I can be heard again after that.
And does the victim, Mr. Reyes, wish to?
Yes, sir.
Thank you for allowing me to be heard today, Judge. I stand before this court not only as the victim of the defendant, former Sergeant Brian Fahey, but as a citizen who still believes in the rule of law that must be applied equally to every person, regardless of the badge that they wear. My first encounter with the defendant took place in June of 2021 at the Connecticut State Police headquarters. The defendant violently grabbed my camera from my hands, threw it to the ground, grabbed me by my shirt, while jabbing his finger into my chest. He later falsely claimed, that he thought my camera was a firearm. No accountability followed, neither from Internal Affairs nor the state's attorney's office. 2 years later, in July of 2023, it happened again. The same sergeant, defendant Brian Fahey, confronted me outside of the barracks, preventing me from entering in the public building, slammed the door on my leg repeatedly, seized my camera from me again, and threatened to arrest me. Again, there was no accountability whatsoever. That continued lack of accountability emboldened him and ultimately led to the incident that brings us here today. During that incident, my cameraman and I went to the defendant's residence to ask about allegations of fraudulent overtime. Apparently, the defendant works a desk job and is receiving $85,000 a year in overtime, more according to him. The defendant answered the door and told me to leave. I began to leave immediately. Video evidence shows that I left within 2.4 seconds and never stopped. The defendant then went inside, called 911, and said, quote, "I am going to shoot him right now," end quote. Those are his words that were conveniently left out of the state police's internal affairs report, even though there was much editorializing and excuses being made, as per usual. His own wife can be heard on the 911 audio begging the defendant not to go outside. He didn't care. The evidence and video footage clearly shows that as my cameraman and I were complying with his order to leave, the defendant advanced towards us with a firearm in his hand, repeatedly bumped into me, and then committed one of the most vile, degrading acts imaginable. He spat directly into my face and inside of my mouth. I will never forget the feeling of that vile spit in my mouth. It was disgusting and degrading. At that moment, I knew exactly what the defendant was trying to do: provoke a reaction so that he could carry out the threat he had just made to shoot me. I am alive today only because I refused to respond to that provocation, and because my cameraman was there. When the Groton Police Department arrived, instead of arresting the aggressor, a state police sergeant, they arrested me and my cameraman for the absurd charge of felony voyeurism, a charge that's since been dismissed. An officer even told me that spitting in someone's face is only a crime, a felony crime, if the victim is a police officer. All laws should protect everyone equally. Only after public backlash and being transferred to this district was the defendant, after a month, the defendant was arrested. No mugshot taken, Judge. No perp walk, just, I would assume, walked in, walked out. That's not what happened to me. And even then, it was only charged with disorderly conduct. Judge, I fully understand that it is not within your authority to bring charges. That power belongs to the state's attorney. But it is within your authority and your obligation to decide whether accelerated rehabilitation should be granted. Under Connecticut General Statute 54-56E, accelerated rehabilitation is a privilege. It is not a right. It may be granted only if the offense is not serious in nature, the defendant is unlikely to offend again, and granting it would not endanger the public interest. This case fails on all three counts. The conduct here was serious, Judge, and violent. Brandishing a firearm, physical aggression, spitting, explicit death threats. The defendant has showed a continuing pattern of aggression and abuse of authority, and granting him this privilege would undermine public confidence in the justice system itself, sending a message that those in law enforcement are beyond accountability. Judge, I mean no disrespect, but I ask you to consider this on a human level. If someone spat in your face and your mouth, brandished a gun, and they were going to shoot you, said they were going to shoot you right now, would you believe disorderly conduct was a just charge? Would you consider it justice to let that person walk away with no record through accelerated rehabilitation? I have been denied justice again and again when it comes to the defendant, Brian Fahey. I have been victimized. My constitutional rights have been violated on camera for the world to see again and again. But today, this isn't about revenge. It's about integrity, fairness, and restoring faith in law. Justice must mean the same thing for everyone, regardless of their title or uniform. For these reasons, Judge, I respectfully ask the court deny the defendant's application for accelerated rehabilitation and set this matter for trial. Only a public trial where evidence is tested and truth is revealed can bring even a measure of justice, not just for me, but for every citizen who believes in accountability under the law. Thank you, Judge.
Thank you, Your Honor. I want to address a few things Mr. Reyes said. I completely agree with Mr. Reyes that equal protection under the law is of utmost concern. It is not only true equal protection, but even the appearance of equal protection under the law needs to exist. It does here. There is another individual involved who the state will ultimately offer AR to. The state would have offered it to Mr. Reyes. He's ineligible. His cases will be heard before Your Honor, as will the other individual on another day. I will say this. Mr. Reyes brings up the prior incidents. The state here is charged only with the conflicted matter that came out of the New London Judicial District that occurred on Mr. Fahey's property, not the other matters. The state feels that disorderly conduct is the appropriate charge. The state has researched the assault statute. The assault statute requires physical injury or pain. That, in the state's estimation, doesn't occur here. Additionally, there is, under the assault on public safety personnel, a specific reference to feces, urine, saliva being hurled or thrown at a public safety officer. And that's why that charge is different than the assault charge. Obviously, if the legislature chose to change that, they could. They have not to date. I need to charge on what's there. There's been much talk recently about threatening as a charge. I will start with the threshold matter that should former Sergeant Fahey have been charged with threatening and assault and disorderly conduct, he would likewise be eligible to apply to this court for accelerated rehabilitation. Those are not preclusive charges. I have done much research, case law. I've done much research with the jury instructions related to threatening, specifically threatening in the first degree, which would be threatening in the second degree by means of with the use of a firearm. I don't think it applies here for several reasons. First of all, in reviewing, we have asked, as the state's attorney's office, I've had an opportunity to review body-worn video from Groton Police Department when they responded to the scene. On scene, Mr. Reyes indicated and was provided, or was going to be provided, a link to Axon to upload the original unedited videos from his encounter with Mr. Fahey. He did not do that. Mr. Reyes spoke to my inspector about turning over a copy of the video. He said he would do that. He did not do that. To date, the state has not received, through counsel or from Mr. Reyes directly, a complete unedited version of the two videos that were out there. So the state is left to charge and review based on reports, based on body-worn camera, and based on edited videos that have occurred online. I will say that in reviewing transcripts and reviewing body-worn video of Mr. Reyes' encounter with at least one of the police officers on scene that night, he indicated he wasn't fearful of the defendant, that he would have engaged the defendant but for the firearm.
Not to be argumentative, but saying that you would have acted differently if not for the firearm is the same as saying that you apprehended that you would be harmed by the firearm if you didn't conduct yourself a certain way. That is exactly subjective fear.
In the state's estimation, the words, which could never have been conveyed that day from the 911 operator to Mr. Reyes, could not possibly have constituted an imminent threat to him at that point. They are, in the state's estimation, bluster. The reason I say that is because Mr. Fahey had a firearm, encountered the defendant, and never acted on those words. If there was a threat that day, it would have been having the firearm at his side, on his own property, by the way, which runs into a gray area of protecting. I know from the threats I've received online that my office has received and Mr. Fahey did indicate he had received threats, not from Mr. Reyes, okay, to be sure, and neither have I, but from people who have commented on Mr. Reyes' video. And thus, the reality is one is entitled to defend oneself or one's family or others. There is justification when deadly threats have been raised against people. In watching the video, Mr. Fahey never, in the state's estimation, as they chest bumped out to the street, raised that firearm towards Mr. Reyes. He turned over the firearm when Groton arrived. And the reality of the situation is that Mr. Reyes himself that day, and in the state's estimation, if there was a threat, it was the firearm itself and not the words that were never heard by Mr. Reyes till some 6 weeks later. Mr. Reyes himself indicated on body-worn camera that in some ways he indicated he sort of saw the actions of Mr. Fahey as being understandable, except for the spitting. What bothered him was the spitting. And in the state's view, the appropriate charge for spitting in that situation is a charge of disorderly conduct, which the state, upon reviewing the file, receiving the file, it took nearly a month to get the file here, and within a week or two, the state had the Groton Police Department prepare a warrant, which the state signed, and it was presented to a judge of the Superior Court. And Mr. Fahey, like any other citizen similarly situated, turned himself in on that warrant. And we stand here today before Your Honor on the AR application. But I wanted to make it clear why those other charges, because there's been much talk about those other charges. And in the state's estimation, those charges are inapplicable to the situation that occurred here. The state's ultimate goal, quite frankly, Judge, is, I know there's civil suits pending, I know there's ongoing litigation. The state's ultimate goal is for Mr. Fahey to stay away from Mr. Reyes and for Mr. Reyes to stay away from Mr. Fahey. And that's the state's ultimate concern. The state does not want this to escalate any further than it has. But based on the actions that I must judge my charges on, and that is simply the actions at Mr. Fahey's house that day, not any previous actions, because I'm left with that simple conflicted incident and not the pattern of conduct, I felt that the disorderly charge was the appropriate charge, and that's what Mr. Fahey was charged with.
Now, when I saw this hearing, I wasn't just disappointed. I was insulted, not only for myself, but on behalf of every citizen in Connecticut who doesn't understand how much they were manipulated on that day. So instead of letting it go, because that's not what we do here, I'm going to break it down. I'm going to show you all of the different ways that this was manipulated, that it was basically a dog and pony show, smoke and mirrors, theatrics, a bait and switch dressed up like justice, but looking readily identifiable as just us. We're talking about a hearing on accelerated rehabilitation, which is basically Connecticut's word for diversion. And a diversion is sort of like a leash that the court puts on a person either before or after they're officially prosecuted and says, if you do certain things for us, we'll do certain things for you. And at the end of this, it'll be like none of this ever happened. Now, to understand what happened, you need to know that there are two kinds of diversion programs, generally speaking, and those are pretrial diversions and judicial diversions. A pretrial diversion is like a waiver of prosecution. The state says, we're going to dismiss this as long as you jump through these hoops. There'll be no plea, no conviction, just an agreement between the parties. We call that in Tennessee a pass and dismiss. Basically, we say, hey, look, you don't get any trouble for 6 months, 12 months, 18 months, whatever it is. We'll dismiss this case, no problem. And then once a case is dismissed in Tennessee, you can get it expunged off your record. But we don't use generally an official pretrial diversionary process. We generally rely on what's called a judicial diversion. And a judicial diversion looks similar, but the defendant actually will generally negotiate for that diversion by pleading guilty up front. And what happens is the court kind of tucks that guilty plea in their back pocket. And then if the person finishes probation and completes the terms of the agreement, the court will erase the conviction. And if the defendant does not meet their end of the bargain, then the judge will enter the conviction. But the difference is what the state has to do in order to get a conviction on a pretrial diversion and a judicial diversion. The key difference is that in a pretrial diversion, if the defendant screws up here, the state still has to prove the whole case. In a judicial diversion, all the judge has to say is, hey, we're revoking your diversion. You screwed up. We're going to enter the conviction as if you pled straight up. That's the difference. Connecticut's Accelerated Rehabilitation Program is a pretrial diversion. It's quick, procedural. It usually takes 5 minutes. And honestly, the burden is on the defendant because the defense is making the application. So the defense is the one that's driving the boat, making the comments. Generally, the position of the prosecutor is we either agree, we object, or we take no position. So from the beginning, this looked really strange because it was, in fact, the state's attorney driving this hearing. He was making the announcements. He was making the arguments. He was deciding who was going to speak and when and all this stuff, right? So the first manipulation that I recognized in this was John Fahey turned the courtroom into a podium for a press conference. And I say that because the hearing should have taken 5 minutes. Instead, it ran 40. Why? Well, because John Fahey needed to use it as a way to speak unilaterally like it was his own personal press conference. And what's strange about that is that every district attorney's office in America has a media relations person. Any prosecutor can call a press conference on any case at any time and the media will be there, especially in a high-profile case like this one that's gotten a lot of attention. They could have said, here's why we charge this way, here's what comes next. But a press conference has members of the media, and members of the media are curious, and they do things that would be problematic for John Fahey and his decision-making. They ask questions. They ask things like, well, why was he just charged with disorderly conduct? What about the spitting? What about the gun? Why is it just a misdemeanor? Why is the state, who would ostensibly represent not independently the victim, but at least the interest of the victim, saying something completely different than what this victim is saying? Why did the police arrest the guy who was spat upon and not the guy who had a gun? But for those reasons, Fahey didn't want that. He had no interest in answering any of those questions. What he wanted was to be able to spin it, to control the narrative in a way that could be unilateral, where he could have 100% control over what gets said and by whom. So Fahey became a master of ceremonies. He was masterful in that he turned the courtroom into his stage. In that room, he could talk uninterrupted under the cloak of absolute privilege, because he made it to where he couldn't be accused of defaming anybody. He couldn't be accused of trying to taint the future jury pool. And he made it to where he could not be held accountable. He intentionally drew attention to Sean Paul's background and wanted the court to know that he wouldn't be eligible for AR, but he would have been offered it. He didn't even really talk about the AR application. Instead, he used that time and that platform to defend his charging decisions, talk about jury instructions, and conduct himself like he was a civics professor, preaching about fairness and balance and all of that bullshit. And none of that had a single thing to do with what an AR hearing is for, which is whether Sergeant Fahey was likely to reoffend or whether the offense endangered the public interest. And I will tell you this, I believe Fahey is likely to reoffend, because this is the first time that anybody has taken note of his conduct and said, there's something wrong with that. Anybody who is in a position to hold him accountable, that is. He has existed for a couple decades, long enough to retire fully with a retirement from the Connecticut State Police with no accountability. He actually doesn't know how to conduct himself like a person who will be held accountable for their actions. And that's evident by the way that he acted in all of these situations with Sean Paul. This dude is a hothead who flies off the handle over nothing, and time again has had his conduct ratified by the people in authority over him. He has no reason to think that what he did here was wrong, because he's getting a sweetheart deal, and he's going to reoffend because he's no longer going to have the coverage of the back of the blue crowd. But what Fahey did here was masterful in a cynical way. He turned a 5-minute administrative hearing into a 40-minute media event conducted in the one place where nobody could ask him a question. That's not prosecution. That is PR from a podium in a courtroom. Now, the second way that Fahey manipulated both the court and the public is that he chose the charge that would itself intentionally determine the outcome of the case. The conduct that we all saw on video, an armed confrontation, words exchanged, spitting in another man's face, it fits perfectly under threatening in the first degree if you start statutorily with second and elevate it because of the gun. The statute says that if you threaten to commit a crime of violence using a firearm, that's it. But it doesn't have to be an outward threat. It can be recklessness. I walked through the entire thing. If you haven't seen my analysis, it's been seen, last time I looked, over 500,000 times on Sean Paul's channel. Over 100,000 people have looked at it on my channel. I went through the entire case and connected it with Connecticut law and said, these are the things that should be charged. So if you haven't seen that, I'll leave a link in the description. Go check it out. But the state didn't charge what would be appropriate to charge under the circumstances. They charged disorderly conduct, Connecticut's legal catch-all for somebody who acted out in public. It's the lowest possible charge that still lets you say that you did something. It's often used as you all know, a proxy charge for contempt of cop. It's not an accident that this happened, because when you charge disorderly conduct, two things happen. Number one, you guarantee that the case is eligible for AR. Now, Fahey went to great lengths to say, well, even if he was charged with threatening first or threatening second, it still would have been eligible for AR. And that's true. Those are not prohibited offenses from the AR process. But the difference is, AR for disorderly conduct, all the judge can consider is what the actual charge was. He can't say, well, he should have been charged with this. He doesn't have the power, as Sean Paul recognized in his statement, to charge anybody with anything. He's literally a neutral and detached referee. And all he can do is decide based on the charge that's presented to the court, because it's the state's privilege to decide what charges fit and what don't. And if he had been charged with threatening in any level or reckless endangerment or whatever, the court would have been able to look and say, okay, well, in light of these charges, is AR appropriate? Now, he probably still would have gotten AR, but at least we don't have to dissect this sort of nefarious intent of the state and watch the state's attorney literally turn his back on the interests of the people in order to protect this blue line thug. And the second thing that happens when you charge disorderly conduct is that you remove the status of a statutory victim. And this is not even something that Sean Paul and I have talked about. I'm not sure he even realizes the distinction. And that's why I say in some ways he may have been manipulated by this process too. Disorderly conduct is an offense against public order. It's not against a person. That means that Sean Paul Reyes stopped being a victim in the eyes of the law the second that the state's attorney decided on disorderly conduct instead of threatening. Threatening has a statutory victim. It's a person. Disorderly conduct is an offense against the public, so there is no statutory victim here. Sean Paul was rendered a mere complaining witness in the process of this prosecution. And then to make it look like it was being conducted fairly, Fahey allowed Sean Paul to speak at the hearing, a right he didn't actually legally have. See, that's the trick. That's the sleight of hand to give the public a performance of fairness while making sure that nothing Reyes said could actually change the result. They didn't go so far as to silence him. They did something worse. Knowing that he would publicize it, they manipulated the process so that they could use his audience and the popularity of his platform and this case to reach the masses and control the narrative in a way that didn't have them answering questions that they didn't have good answers for. And that leads me into the third manipulation that John Fahey exacted upon the people of Connecticut and the court, and that is misleading the court about the merits or the elements of threatening. And you might say, well, I mean, how could he mislead the court, James? Because judges understand what the elements of threatening are. No, there are hundreds of statutes. I'm telling you, judges don't know elementally all the offenses for which the people were charged in their courtroom. They just don't. There are hundreds of statutes. These guys sees thousands of people. The judge wouldn't have known whether the pattern jury instructions were or were not exactly what John Fahey said unless he took it upon himself to do the research. Okay, so that's the most insulting part, was Fahey told the judge and anybody else who was listening that the elements of threatening weren't met because Sean Paul didn't know about this 911 call where Fahey says, I've got a gun and I'm going to shoot him right now. Therefore, he couldn't have been afraid. Well, that position is either ignorance, and I don't think John Fahey is ignorant. I think he's manipulative, and I think he knows exactly what he's doing, or it's deceit. And I'm not really sure which is worse, but I know that John Fahey is not ignorant. Let's pull up Connecticut's own pattern jury instructions here to make it clear. I want to draw your attention to the fact that Sean Paul said in his statement that he would have done a certain thing or hadn't done a certain thing because he saw the gun. That means that he apprehended it. So you have the subjective apprehension of the gun, and you also have the recklessness with which Fahey conducted himself. So these elements are met according to the pattern jury instructions, regardless of what Fahey says. But even if you didn't have subjective fear, the statute does not require it. It has a recklessness component. If this was only provable through subjective fear, it would be called scaring and not threatening. Threatening is the focus on the person's conduct, not the impact, right? That's the point. Now, to me, what's so offensive about what Fahey did here is that a skilled prosecutor can literally make you see whatever they want you to see. A skilled lawyer, like defense lawyer, can create reasonable doubt or get past the preponderance of the evidence as a legal standard with storytelling. But a skilled prosecutor, he already has the public trust. They know that the jury is going to give him a head start on his burden of proof. All he has to do is choose the story to tell, and they will believe him. So if you don't want to charge threatening, you split the story into two pieces. You say, well, Sean Paul Reyes didn't know about the phone call. He didn't know what the subjective intent was. And then Fahey didn't go out there and do what he said he was going to do. So there's no way Sean Paul could have felt fear. Therefore, threatening doesn't apply. He completely ignores the fact that there are other theories to threatening. If you want to get a conviction for threatening, you take those two things and you put them back together. You take the phone call and you take the act and you put them together to have criminality. Let me lay this out like a prosecutor would speaking to a jury for closing arguments if they were actually charging an appropriate charge and seeking a conviction. Ladies and gentlemen, you are smart people. You've lived in this world. You have your own life experiences to rely on. This is really not a complicated case. The things that you've experienced in your life, the conflict that you may have had, has equipped you to completely understand how this stuff works. You can use critical thinking and the evidence in front of you to find the truth. And I want you to know that we trust you to do that. In fact, I helped choose you. The defense counsel helped choose you. We got together here and we had dialogue with you. We asked you questions to make sure that you were fit. We heard your answers, and each and every one of you was individually chosen to participate in this process because we have confidence that you will deliver justice. This case is not complicated. What we have here is a defendant who said on the phone, "I've got a gun and I'm going to shoot him right now." And then he went outside and did everything in his power to make that a real threat, except that he didn't actually pull the trigger. Now, the defense is going to go to great lengths to explain to you that, Sean Paul Reyes had no idea what was being said to 911. He didn't know anything that was being said to the operator. He had no idea what Mr. Fahey's wife was screaming about. He had no knowledge whatsoever of the intent of the defendant. And therefore, you must find the defendant not guilty. But ladies and gentlemen, I submit to you that you are too smart to be manipulated by that nonsense. We don't even need a 911 call. In fact, just forget about it for a second. Pretend we have no idea that a 911 call wasn't ever made. Do you think that in the course of prosecuting major crimes in this country, that prosecutors always have a bunch of evidence, or we are gift wrapped with a 911 call where the perpetrator calls 911 and tells the operator what he's going to do and why? Of course not. We almost never have that kind of evidence. So how do we get there? How do we cross the goal line of proof beyond a reasonable doubt and deliver it to you so that you can make the right decision? Well, we do it by starting with people like you, reasonable people. And then we lean on the law for guidance. The law tells us that intent coupled with conduct make a crime. And in this case, the defendant has shown both. Think about what you know about the psychology of chest bumping someone. What kind of mindset would a person need in order to do that? If I want to start a confrontation with somebody and I push them, I've pushed them, but I'm still extending my arms here. I'm still creating distance. I'm still going to allow for the fact that I don't know what you're going to do in response to my push. So I'm going to create this distance. When someone chest bumps another person, that's not confusion. That's not an accident. That's a deliberate act of intimidation and a threat of domination. It's meant to close the distance even more than a push. It's erasing personal space. And it communicates only one thing to a reasonable person: I'm in control and you are not. And you should be very, very worried about what I'm willing to do because I'm not afraid of you. In my mind, there are only two ways that move makes any sense at all. Either one, the person doing it is so confident in their ability to prevail in a fight that they're inviting one. Or two, they're so emotionally out of control that they're ignoring the very real risk of starting one. In either case, the intent is the same: to intimidate, to provoke, to establish physical dominance, to create an apprehension in the other person. You do that unarmed, that's one thing. But you add a firearm to it, well, ladies and gentlemen, that's why we enhance the offense from second to first if you have a firearm, because that same gesture now carries a second layer of meaning. It says, if my hands aren't enough, I promise you this gun will be. The chest bump shows the willingness. The gun shows the means if my hands don't work. So I want you to think about the victim walking backwards down the driveway. How afraid any reasonable person might feel. What if I trip? What if I do the wrong thing and he shoots me? Is this the end of my life? Is this the last time I'm going to see my wife, my kids? Are we seriously going to sit here and pretend that because we don't hear Sean Paul Reyes pleading for his life or expressing actual fear in the moment that it tells us that he was not afraid? The law doesn't even require that you be afraid. And you can't convince me that any person who values his life would not feel fear in that moment. But we don't just have to rely on the conduct. We still have that call that I told you to forget about.
I have a gun and I'm going to go shoot him right now.
The words of the defendant, I have a gun and I'm going to shoot him right now. We have the defendant's wife screaming in the background, exhibiting her own fear or apprehension, begging her husband not to do what he's about to do. She knew it was wrong. Anybody knows it's wrong. This phone call does all the work for you because it ties the conduct to the mental state together with the clearest possible statement of intent. Now, the defense desperately wants to separate those two things, to say, well, the threat happened on the phone and then the conduct was over here and the confrontation happened outside, but the law does not require them to occur in the same breath. What matters is the continuum of intent. It started here, it continued. It's one continuous act. He made a decision, he voiced it, and then he acted on it. That's not two acts, that's one crime unfolding in sequence. Now, I ask you to consider this. If the roles were reversed, if a citizen had called 911 and said, I'm going to shoot that trooper right now, and then he walked toward the trooper, armed, bumping chests, and spitting in his face. Does anyone in this courtroom have the ability with a straight face to say that they believe that citizen would have been able to separate those statements from his actions? Of course not. So don't be manipulated by the fact that this guy used to be a public servant. He is just a defendant who committed a violent crime and needs to be held accountable. And for that reason, I ask you to do what is obvious or should be obvious to everybody in this courtroom and find beyond a reasonable doubt that Brian Fahey is guilty of threatening in the first degree. Now, that's what I would say if I was a prosecutor, but I'm not a prosecutor. In closing, John Fahey didn't just undercharge a cop. He scripted a performance to defend the decision in real time from the only stage where he could speak unilaterally without challenge. He used a courtroom the way a politician uses a podium, to manage optics, not to seek justice. He let the victim speak for show, but made it to where he wasn't actually the victim. And then he took the mic to explain why his own office was beyond reproach. The irony is that the only person telling the truth in that courtroom was Sean Paul, and everything he said in that hearing was correct, but by design, none of it mattered. The outcome was baked into the cake from the moment they chose disorderly conduct instead of threatening. And that's why this matters, because if the state can undercharge one of their own, use the AR process and then the courtroom to launder the narrative and call it transparency, then the rule of law has basically become non-existent, which I know is how most of you feel anyway. But it's important to remember that the state's attorney represents the interests of the people in that state. The people's interests are never served by manipulation and using insider trading secrets to piss down their back and call it rainy season. Now, earlier I mentioned that this situation was dressed like justice but looked like just us. I've become convinced that justice has become so performative for the John Faheys of the world that they don't even recognize what real justice looks like anymore. They've become so entitled to the power and the ability to manipulate the system that it really is just us. It's just their game that they play. They don't know anything else. And until we replace those people with reform on the mind, it's not going to get better. I wanted to kind of give my thoughts on this. One, because Sean Paul asked me to, and two, because, this can look like something it's not, which is that the state's attorney's trying to do the best he can to sort of please everybody. And that's not what happened here. This was total manipulation. Don't fall for it. Keep letting your voice be heard. And I've had a couple people in the comments who've said, you ought not pay attention to Sean Paul because he's had a history or a past. And I don't know what Sean Paul's previous, I don't care. Here's what I'm saying to you. You got to do a couple things. One, you either got to stop being a fucking idiot and think for yourself, or you got to stop coming into the comments section talking about how corrupt and rigged and not trustworthy the system is. If you're going to say with the same lips that we shouldn't trust or believe in anything Sean Paul's doing because he's a convicted felon. And again, I don't even know if that's true, but that's what people say, right? I haven't talked to Sean about it. It's none of my freaking business. But what you're saying, though, by immediately reducing his credibility because he's got a felony conviction, if that's the case, is that you're putting stock in the system that got him there. We don't know whether the charges against any person who's been convicted of a felony were legit. We don't know whether the system was manipulated and rigged like it has been right here in front of your face. So let's stop just discounting human beings because they didn't have the resources or the wherewithal or the life experience to know they were getting screwed by a system they thought was there to protect them. Can we do that, please? Anyway, thanks for watching, guys. I hope you got something out of this video. I'd like to invite you to check us out on all of the socials. You can do that by scanning the QR code on the screen. You can actually join on a paid tier of Substack if you want to, but that's only for people who want to support the channel monetarily. I don't put anything on these platforms that people have to pay for, but I would like for you to follow us on TikTok and Facebook and help us get to 5,000 followers by the end of the year. If you don't want to follow us to another platform, but you'd like to support monetarily, I'll put my Venmo and PayPal links both here on the screen as well as in the description. Please remember to like and subscribe and leave a comment on the video. Only about 15% of the people on the channel actually subscribe. It really goes a long way in helping the algorithm help people find our videos. So please subscribe. It costs you absolutely nothing. Check out some of the other videos on the channel and leave a comment on there as well. Until I see you again, take care. Always film your interactions with the police and keep your evidence to yourself.